Hey, good morning. My name is Roger Zelaya. I am the broker of record for Radius Agent. And what we have here today is a good friend of mine and somebody that really is very, very good at probates, trust, estate planning, etc. So let me tell you who he is. Sam Price is an experienced and highly educated attorney who's passionate about helping others. Sam's exceptional talent is to make complicated legal jargon and court procedures simple and easy for his clients to comprehend. Sam has practiced law for 24 years and is a certified specialist in estate planning, trust, and probate law by the State Bar of California Board of Legal Specialization. That's a long one. Sam is a member of the California Lawyers Association Trust and Estates Executive Committee, where he reviews California legislation regarding the areas of trust and estates. Sam is the managing attorney of the growing boutique law practice Price Law Firm, which focuses on estate planning, trust, and probate law. He is the founder of probatedocs.com. I didn't know that, which provides software for completing the forms and documents to complete probate cases. He made such an impression on an author client that she based a character of a probate attorney on him in real life novel entitled Battle of the Wills. He assists clients with protecting their family through planning. Sam helps successor trustees administer trust after the passing of the seller. Sam has a passion for public speaking and teaching. He is the chair of the estate planning and probate law section of the San Bernardino County Bar Association, providing monthly educational presentations and an annual probate symposium event, which I've been to. Sam earned 2 law degrees with Masters of Law degree from New York University School of Law and a JD with honors from Western New England College of Law. He earned his Bachelor's of Arts degree in Business Administration with a concentration in finance from Cal State San Bernardino. When he's not working on a legal matter, Sam values his time spent with his family, his British TV reporter wife, Tiffany, their preschool-age son, and their beagle, Poppy. His other great passion is woodworking and has designed and built a number of unique pieces of furniture in his office. I didn't know that about you, Sam, so I learned something new today. So today we have Sam, and he's going to give us a presentation on probate, how to sell property through probate, etc. So take it away, Sam.
Thank you so much, Roger, for having me here for today, and thank you all for being here. I think I'm going to shorten that intro to just the probate badass of San Bernardino and Riverside counties. So I'm going to take I'm going to take your suggestion, Roger, and just shorten that whole thing up. I'm going to start presenting my screen, and here goes. And I will put this in presentation mode. And so what I was going to talk today about was selling real estate when the owner has died. And what I'm going to welcome you to do is, if in my lawyer brain, I kind of started talking and thinking about things that I thought you wanted to talk about, if you want to go ahead and unmute yourself and ask me a question, I'm really happy to just take this in a different direction if you want to talk about something else. So let's get started. First, I want to kind of talk about when is probate needed. And whenever you have ownership of real estate and the owner dies, if you have more than one owner of the real estate and there's some type of right of survivorship, you're not going to need a probate matter. So in this example, we have Harry and Wendy, who are Harry Smith and Wendy Smith, husband and wife, as joint tenants. If there's a surviving joint tenant, if Wendy's still living and Harry dies, you don't need a probate attorney for this, and you don't need a probate case. Same thing if you have a trust, and if there's a trust that owns property, if you have John Smith, trustee of the Smith Family Trust, dated June 12th, 2023, you're not going to need a probate case for that. You might need trust administration. The successor trustee may need some help to administer that trust, but you're not going to need a probate case for that. I just see the question in the chat. Yes, my office does handle administration of trust. Our office doesn't do that. We help the successor trustee to manage those trusts. But you are going to need a probate case, and you need to call a lawyer when you have one individual owner of the property and that person has passed away, or you have more than one owner of the property and there's no right to survivorship. So, for example, if they're tenants in common. So if the vesting says Simon Smith and Debbie Johnson as tenants in common, or there's no vesting at all, then there's no right to survivorship, and there you're going to need some type of probate matter. So if there's one owner or there's no right to survivorship, that's when you're going to need a probate case. Now, your clients might ask you, what is probate? Probate court is just a process. It is a procedure through the courts that appoints a personal representative in order to be able to list and sell the property, pay the debts, and get all the assets out to the heirs of the estate. Your clients might ask you, when can I sell the house? How much does probate cost? How long does probate take? And when do I get my inheritance to buy another house? So let's dive into that. Here's an example of what probate will cost for different size estates. So I have the example here of a $500,000 estate. That's a pretty typical home these days. In some places, it's only a condo. In other places, and maybe in some places, it's just vacant land. But usually this is an example. The attorney's fees are set by California law as a percentage of the total value of all assets of the estate. 4% of the first 100,000, 3% of the next 100,000, 2% up to $1 million, 1% up to $10 million. On a $500,000 estate, that equals $13,000. Now, the executor or the personal representative is entitled to the same fee for being the executor or administrator of the estate, $13,000. And then I'm estimating about $2,500 in court costs and other costs. That's going to be about $28,500 for a $500,000 probate case. Now, my office, I'm going to wait until the house sells for my legal fees. All I need is a deposit of about $2,000 to get a court case started. That's enough to pay for publishing the newspaper, filing fees with the court, and getting the case started. But I'll wait for my legal fees till later. And so that's a typical cost for a probate matter. You can kind of take a look at the total estate values to see. I've got them listed up to $3 million for an estate to see what those costs and fees would be.
Sam, and
yeah,
and if you go back to that one slide, when we're talking about $500,000, is the value of the estate, not necessarily the house, because the house could be $475 and they may have some cash, correct?
Yeah, it's the total value of the entire estate, all assets that go through probate. And typically what I'm seeing are a house, a bank account, a car. That's the most common assets. Sometimes people have a brokerage account with stocks, bonds, and mutual funds in it. But that's about the typical estate. Sometimes an estate is just cash. Sometimes it is, I'm probating an estate where the decedent was a writer. He was a screenwriter. He wrote scripts. He wrote a movie that came out in December. It was called How the Gringo Stole Christmas. And George Lopez was in it. So, but he just passed away recently. So sometimes it's whatever the assets might be, and it's on the gross value, not the net value. But good question. It could be more than just a house.
Thank you, Sam.
Yeah. So this is kind of the process and timeline of a probate case. So the very first thing that we do is we kind of start with preparing a petition for probate. I gather information and documents from my client, and that would be how we get the probate case started, with filing with the court. Once it's filed with the court sets a court hearing date. And in the meantime, before the court hearing, I am publishing in the newspaper and I'm mailing out notices. Then at the court hearing, I'm expecting the court to approve appointing my client as the personal representative of the estate. And once they get appointed, they get what are called letters of administration or letters testamentary. And what that does is that's their ticket to be able to sell the house, sign a listing agreement, gather money in the bank account, sell the car, do everything that is needed to gather assets, liquidate what's needed to pay the bills, and then after we've finished administration of the estate, now we move on to stage 4, that is going to be how we prepare a final petition with the court. Again, I'm gathering information and documents from my client to be able to draft that petition. I get it on file with the court. The court sets a court hearing date. And in the meantime, I'm mailing out notices. At the court hearing, I expect the court to approve that petition and ask for a distribution of the estate. So when can your client be able to sign a listing agreement and be able to sell the house? At stage 3 here, where we're in administration of the estate after letters are issued to the clients. Now, I say the word letters, that's what they're called, but they're a different type of letters. And the word letters goes back to that time when there was a king in England, and if you needed permission from the king to be able to do something, he wrote letters of marque and reprisal. Letters of marque and reprisal made you a pirate. That allowed you to pillage and plunder other ships of other countries. Here, letters testamentary means that there's a will and that you're appointed as the executor under that will, or letters of administration means that there's no will. So sometimes letters are called different things. Sometimes they're called letters of administration with will annexed, meaning that there's a will, but this person wasn't appointed as the executor, nominated as the executor in the will, but yet there's still a will. So I'm going to start just calling them letters so that we know that we're talking about the same thing. But letters is a one-page document. I'm going to show you what that looks like. I'm so sorry, was there a question?
Yeah, Sam, if I may add, for those of you that are agents, right? Everybody here is an agent. I have had, a probate where they signed the listing agreement on step 1, subject to letters. And that is the administrator at the time did not have the authority from the court to bind the estate, on a listing agreement. So it's important for you guys to understand the probate timeline, because then I called that agent and he's like, nope, we got an agreement. I called his broker and we said, no, we don't, because you didn't have order for probate or letters at the time, and we ended up getting the listing. Just wanted to throw that out there for you guys. So understand the probate timeline because it's super important.
Yeah. And so, it used to be I could kind of get a case done in maybe as few as 8 months. Looking at this timeline, and when we're in stage 3 where the person has letters, I must leave the case open for at least 4 months from the time they get letters, because that's the time period where any creditor can file a creditor claim. I can't close the case before that. So that's a 4-month period. Getting a court hearing is a couple months here and there. Delays. Could I get one done in 8? Sometimes, but that's rare. Nowadays, a probate case is taking about a year to a year and a half. And the other important thing about a listing agreement is that, and I'm going to talk about this later on, the listing agreement cannot be more than 90 days. And so if you're in stage 1 signing a listing agreement, and then you're going to have to renew once the person gets letters, maybe a couple months later or 2 or 3 months later, then you need to be able to renew that listing agreement with an addendum, because they cannot automatically renew, and it can't be more than 90 days at a time. So super important that the person has the right authority from the court, and letters gives them that authority. So we talked about this. It takes a couple months, to get letters. We're talking about 12 to 18 months, a year to a year and a half to complete the entire probate process, and for these heirs to receive their money. And that's important, because then you're going to know when they're going to have enough money to be able to get a down payment for another house. The other issue is sometimes people are living in the house and they need a place to stay, but they're not going to get their inheritance for like a year to a year and a half after the probate case is started. So that's some important things to understand and be able to counsel a client about.
I'm sorry, Sam. I have somebody saying they cannot see your screen. I can see Sam's screen, and can anybody else see their screen?
I can't.
I can see the screen.
Okay.
Is there a way to find it?
Possibly, Emily. I don't know, but okay. Sorry, Sam. Go ahead.
There might be some different views that are available in Google Meet. Maybe taking a look at the different ways to view.
By the hand on the right, there's more options. There's 3 dots, and click on that and see if you can change the layout.
Okay. Thanks.
Thank you, Sam.
Cool.
About that.
Yeah,
you.
of course. No, yeah, no problem. No problem. So on the screen, what I'm showing are a copy of what letters are. And you see it's just one page, even though they're called letters. Here, these are letters of administration, and it shows you who the personal representative of the estate is. So that this Lucille Marie Toscano, she was appointed as the administrator of the estate of Lynn Mary Toscano. And it's also in that second yellow box on line 3, it is showing you whether or not that personal representative has been granted the authority by the court to either have full authority or limited authority. Here she has full authority. And also, and I'm going to talk about what the importance of that is in just a sec. But I'm also wanting to show you what a certified copy looks like, because escrow is going to need a certified copy of the letters in order to record them with the county recorder's office. Even though this is not a notarized document, if it's a certified copy by the court, then they'll be able to record it. And so here, where it says certification in the bottom right-hand corner of the letters, it does have the purple stamp seal of the court, and of course it's signed and dated by the court as well. Now, this is a copy from San Bernardino County. Riverside County, their stamp is red. Los Angeles County, their stamp is black. You might see different colors on that stamp. But I just wanted to give you an idea of what those letters look like and what you'll need to have in order to close escrow. So going back to talking about whether the personal representative has limited authority or full authority to be able to act, it depends upon how much authority the court is giving them to be able to do work on their own without having to come back and ask the judge every time. And if you have limited authority, you have to keep asking the judge for permission to move forward. And if you have full authority, you don't necessarily have to keep coming back to the judge. And the difference between limited authority or full authority, it's all about a probate bond. So a probate bond is kind of like insurance, but it's a little different. So with insurance, if you get in a car accident with your car and you cause an accident and there's damages, your insurance company will pay that and not ask for the money back. You don't have to pay back your insurance company. The insurance takes care of it. A bond is different. If a bond company has to pay because you committed some negligence or a wrongful act, if the bond company has to pay, they want their money back. They're going to come after you for the payment. Now, it's not like Dog the Bounty Hunter is going to come to your house, but they are going to try some legal means to recover the money that they pay for you, because a probate bond makes sure that there's always someone there to be able to pay for damages if the money of the estate is mishandled. Keep in mind that the personal representative of the estate, even if they're the only child of the decedent and is entitled to 100% of it, none of that money is theirs until a judge orders it. And so because we have someone who is acting in a fiduciary capacity, we have this personal representative that is handling money that's not theirs, a probate bond makes sure that there's at least a payment source if the money is mishandled. So with this probate bond, sometimes the bond amount is really high and people don't qualify for the bond, or because the bond is high, it's very expensive. I've seen a $4,000 a year annual premium for a probate bond based on $1 million estate. And so the expense of this could be a lot for someone who didn't expect to have this expense because someone has died. So, and not everyone's going to qualify for $1 million bond. So if they can't qualify for bond, or if it's too expensive, but we still need to get them appointed by the court, sometimes I might make a deal with the court, and not a deal, but rather I'm trying to see what I can do to assure the court, the judge, that the money won't be mishandled. So maybe I say, look, why don't we give them limited authority? Then they have to come and ask permission to sell the house, and then the judge knows what's going on through the case. Sometimes I'm asking for a reduced bond. I'll tell you, if someone lives out of California, they live somewhere else, they're going to have to serve a bond at some amount. And so sometimes I could either get the court to reduce the bond or eliminate the bond, but the judge wants different assurances that the money won't be mishandled of the estate. And so that's why sometimes I have to agree to my client serving with limited authority. Let's talk about once someone has letters and we're going into getting a listing agreement. So there's going to be some forms required. You're going to need that disclosure regarding real estate agency relationship. There's that residential listing agreement. You're going to check that box saying that the signature line is an entity sellers, because this is the personal representative as the of the estate that is signing the listing agreement. You'll want to have that probate listing addendum and advisory, and any other local forms or risk management forms that your office might want you to have. Again, the listing terms, it cannot be longer than 90 days. There cannot be an automatic renewal after the 90-day period. You have to sign a new addendum each time. And if there is more than 270 days of the listing, well, gosh, if there's more than 270 days, that's 9 months. Something's wrong with the property, or something's wrong with the seller's expectation of what they should be selling that property for. The personal representative with full authority can give a notice of proposed action to renew the listing agreement. The listing should say that the sale is subject to court confirmation. That's always a possibility, and I'm going to get into that in a little bit. And the disclosure requirements of the civil code for probate sales are exempt, but that doesn't stop the personal representative from the common law disclosures rather than the civil code disclosures that might be required. And certainly that would include any type of issues with either the desirability or the value of the property that the seller knows about or should have known about. The commission cannot exceed the amount the court will allow. I will show you how much that will be. I don't think the courts have caught up with California law with the National Association of Realtor changes that they've done to commission structures. But still, I want to talk about that just so that you guys are aware of those changes. And then the sale should be as is with no warranties except warranty of title. So that should be part of the listing terms here. Now, if the client has limited authority, the listing terms are the same as a full authority. However, with limited authority, the personal representative must seek court approval before entering into a listing agreement for an exclusive listing agreement to sell real estate for no more than 90 days. Now, sometimes we ask for permission from the court. Sometimes we ask for forgiveness, because if we have signed a listing agreement prior to asking the court with limited authority, sometimes when we're going to have to ask the court to confirm the sale, so we might as well ask them to confirm that the listing agreement was valid as well. Now, with limited authority, if we're going over 9 months for the listing, we must again seek court approval, and we have to show that it's in the best interest of the estate to continue with that listing. So there's a couple more requirements here when you have limited authority. Here, we're going to talk about the broker's commissions. So even with a listing agreement, the broker's commission, as well as the cooperating broker's commission, the judge can determine what is a reasonable compensation. Local rules of court will limit how much the broker's commissions can be in total. The broker is entitled to commission when an actual sale is made on a fully executed purchase agreement. The sale is confirmed or approved by the court, and the sale is consummated, so escrow must close. So there's no procuring cause in probate. So if you bring a ready, willing, and able buyer on a full listing price, you still aren't entitled to a commission until escrow closes. The sale has to close. Now, the broker is not entitled to a commission if the agent or broker directly or indirectly is the purchaser of the property, or the agent or broker has any interest in the purchaser of the property. So if you buy it or you are part of an investment group that buys the property, you are not entitled to a commission. And this is all probate code requirements, even though you might have a listing agreement that says otherwise. Here are the maximum commissions allowed for different counties in the area. So for improved real estate, for San Bernardino County, it's 6%. Riverside County doesn't have a maximum. Orange County has 6%. Or LA and San Diego County are both 5% max commission. And that's going to be both the seller and buyer's brokers. For unimproved real estate, for vacant land, each county is going up to 10%. So it's a bit higher on land commissions. For the probate property sale, this should be the same process that you might be familiar with, except there's a little twist. There's step 3. So step 1, you're going to list the property for sale. You enter into that listing agreement. You're going to advertise the property for sale in the multiple listing service. You're going to accept an offer. Your seller is going to accept an offer by a buyer. And once we have that accepted offer, we need to give notice, or we have to get court confirmation. So that's an additional process than what you might be used to. And then fourth, we're going to close the escrow. So when you're listing that property in MLS, you want to disclose that the property is being sold through the probate process. And you want to say in the listing that all offers are subject to court confirmation and overbidding, and that the property is being sold as is. When you're presenting offers on the property to your client, the personal representative has the option to accept, reject, counter offer, or request highest and best offers on all offers submitted. The personal representative can accept the price and terms of the sale. They do not have to get permission from the other heirs to sell. This is not a democracy. This is a probate case is a benevolent dictatorship where the personal representative has to act in the best interest of all the heirs to the estate. But we don't want to accept something that there might be an objection to that sale. So the personal representative isn't going to sell it to their friend at a discounted price. They're going to accept the best offer that is presented. Now, the personal representative has a fiduciary duty to act in everyone's best interest and to sell that house for the best price possible. But sometimes that always isn't the highest price, right? Sometimes there are reasons why we might accept an offer for not the highest price, but rather the best offer, because there's less contingencies, or the financials of the buyer are better to get a loan, or what have you. They might be putting a bigger down payment down. There's different reasons why we might not accept the highest price. But if that's the case, you want to keep a record of all the offers on the property, because if one of the heirs says, hey, you know what, you accepted this offer, it was marketed for 2 or 3 weeks. Is this the best offer that you've gotten? And if you can show and compare all the other offers on the property to show why you accepted the offer and it's the best, you'll want to keep records of all the offers on the property. So this is that 4-step process to sell a property, but I've broken it down a little bit more. So you're still going to list the property in number 1. You're going to get that listing agreement. And then in number 2, you're going to accept a purchase agreement. The seller is going to accept a purchase agreement from a buyer. Now, if a personal representative has full authority, then they could do a notice of proposed action procedure. That's something that I do. It's a form that is mailed out, just giving everyone a copy of the purchase agreement, letting them know what this house is being sold for. And if 15 days goes by after I've mailed it and no one objects in writing, then we can go ahead and move to step 4 and close escrow. If all the heirs consent to the sale, and sometimes I have an offer from an investor, and they really want to close fast. They want an 8-day escrow. Well, I don't have to wait 15 days if all heirs consent. So everyone can sign a consent, and then we can move forward to step 4 and just kind of close the escrow. Also, all the heirs to the estate can waive their rights to a notice of proposed action, and again, we can move to step 4 and close the escrow. However, if anyone objects, if I get an objection from one of the heirs to the estate, or if our personal representative has limited authority, then we have to seek court confirmation of the sale. And so we're still stuck in the stage 3 if we have to do this court confirmation of sale, because it requires that I file a petition with the court. The court's going to set a court hearing date. In the meantime, I got to publish in the newspaper. The court clerk is going to post something inside the courthouse. I have to mail out written notices. And then at the court hearing, the judge conducts an auction. And sometimes there's people overbidding and sometimes there's not. But once the court confirms the sale of the property, then we can move on to stage 4 and close that escrow. So this is kind of like that same list, accept a purchase agreement, give notice or court confirmation in order in step 3, and then 4, close the escrow.
Sam, if I may add something here, it is crucial and super important for you guys to understand probates. And if you can get certified, because the certification will dive a little bit deeper in here. But I can tell you that I have I've followed up on administrators, and then they end up going with a friend of a friend of a friend of a friend. that doesn't understand probate, and here we are at day 28, and now they're frantic because they want to close because they never told anybody that a NOPA needed to be filed, and then their closing is going to be delayed by at least 15 days unless they they waive it, right? They do the NOPA waiver. So it's important to understand all of these nuances because you may get delayed. And sorry, there was one more question on the chat, Sam. When you say give notices, is it snail mail or electronic?
Snail mail. Yeah, the probate code provides for mailing, but the 15-day period starts when I mail it, so not when they receive it. So whether you live in Florida or down the street in California, your 15 days starts when I mail it. Good question.
Thank you.
The other thing that escrow is going to want to see is they're going to want to see that this notice of proposed action procedure was completed, or if we have a court confirmation of sale, the order confirming the sale, they'll want to record a copy of the court's order. So in order to close escrow, if I did a NOPA, I'm writing a letter to escrow explaining that we've given the NOPA and either 15 days has gone by and there's no objection, or all heirs consent, or everyone's waived NOPA. One of those three things has to have happened for escrow to be ready to close, because title won't let them close without having completed this process. Or again, if there's court confirmation of sale, having a certified copy of the court's order so that we could close the escrow. So
Quick
on that
question.
note, yeah.
Quick question. Sorry to bother you. With the if you have one heir, what percentage of cases do you have an heir who doesn't agree to the terms?
Very seldom. And I hope this doesn't bother anyone that I say this, but I don't know why, but every time someone objects, they live in Texas. I don't know why that is. Not
They
saying
hate
anything
Californians.
it could be. I don't know. They're a little more independent there. So someone might object, and although I'll try to work with someone who objects and say, hey, listen, you objected. Can I please ask you why? And maybe there's something that we can solve to save time and money from the estate from having to do a court confirmation of sale. Perhaps they don't fully understand that this is the best offer, or it was widely available for sale, and there's no backroom deal between the buyer and the seller. Sometimes we could get the objection waived if we kind of take the time to give more information and explain. That's why sometimes it's really important to keep all the offers so that we could show them and say, look, we took the highest offer. If you have someone that will pay more for the property, tell us. We'd love to sell it for more, but this is the best offer and we took it. So occasionally we do get some objections. Usually it's someone from out of the area or someone that's not quite familiar with the process and they don't quite understand what's going on. So sometimes my office has to take the time to explain that. But it's seldom. Out of hundreds of cases, I probably less than 1% get an objection.
Thank you.
Yeah.
If I may add, most of the cases that I've worked on do not object, but I have noticed that there are some people that are, I don't know if it's objection, Sam, or it's really they go to litigate the estate where the order for probate has been issued, the letters have been issued, and then there's some random person that we've never heard of that comes out and makes an objection to the estate, and I'm ready to take the listing agreement, and then we pause.
Yeah, no, that happens too. So many different things can happen. Sometimes that someone objects not because the price is too low, but because maybe one of the heirs to the estate lives in the house and they're trying to delay having to move out, and so they file an objection. And we have to do an eviction. Maybe sometimes there is some family dynamic issues where it's not about the money or the sale of the house. It's about decades of hurt feelings that has nothing to do with really selling the house at all. So this is probate, and sometimes it gets a little messy because we're dealing with families. And so sometimes the objection isn't necessarily just about the price of the house either.
But in California, tenants have lots of rights now, and so how is probate any different with regard to the tenancy laws?
No. So when the owner of the real estate passes away, none of the rights of the tenants goes away. So if someone is on a term, if the tenant is on a term, they have a lease, they can live out for the rest of that lease. The death of the owner of the property doesn't terminate the lease. They can continue to live there until the end of the lease term. If they're a month-to-month tenancy, you could terminate that tenancy with the proper notifications. Usually that is over a year that they've been there. You have to give 60-day notice. Otherwise, you can give 30. Or there's someone who is there that there is no agreement. They just live there, but they're treated as a month-to-month tenant. And so if we have to do an eviction, it could be because non-payment of rent, or we could terminate the tenancy with the proper notice. But none of the laws change because of a probate matter. It's still the same eviction process that is for even if the person was alive. It's the same.
If I may add, I have a case. It's a probate case in County of LA. The administrator lives in Georgia, and we've been trying to kick out the stepbrother because he lives in the property. And it's been a year and a half. Anybody want to take a wild guess what county it is? Los Angeles. So,
Yeah.
And he's still there, and we still cannot sell the house.
Well, that's what I'm saying, is that people will dig in and they have right. And it's not just a 60-day eviction. It's like on some properties you have to be the owners moving in, etc. It's like, I just wondered with probate if it's for a probate sale, if some of those things go away, or do the tenants have the same rights as they would in a regular tenancy situation?
Same
Yeah,
right.
good question. They have the same rights.
That's why it's taken a year and a half.
Yeah, it's
Well,
been
it takes a year and a half without the eviction. The probate process does take that kind of time. And sometimes it's a delay from the client can't get information that I need, or sometimes it's the court is backed up and they have the hearing dates really far out. Sometimes I e-file something with the court and it takes them 3 weeks to process the e-filing. So sometimes the delays could be for different reasons, not necessarily for an eviction, but an eviction will put the stop on things. Now, look, you could sell a property with someone in it. It's just going to sell at a substantial discount because now the buyer has to deal with it. And so that's an option that's available. But again, only an investor is going to buy that property and they're going to want a big discount.
Yep.
Yeah, but good question. Good question.
Thank you.
Yeah, of course. So now when we have an accepted offer, this is what I'm going to need from the broker. So I'll need the listing agreement, the purchase agreement, and any addendums. Put me in email contact with the escrow officer. And if the terms of the sale change, if you have some type of seller concession or something that changes the terms of the purchase, then I do need to probably give a new notice of proposed action to give everyone notice of the change, especially if it changes how much the estate will receive in the sale. It'd be helpful to get the estimated closing statement, and I do need the final closing statement after escrow closes. Now, talking about that court process of confirming the sale, if it's required, there's going to be an auction in open court. And before the hearing, it's a lot like a foreclosure sale where the bidders have to show how much in cashier's checks they brought with them, because they don't have to pay for the entire property at the hearing. They have to put at least 10% down on the purchase price. So at a court hearing, I'm going to have bidders come up to me and they're going to qualify themselves with cashier's checks. So whether that might be they have $50,000 of cashier's checks made out to themselves, and they'll endorse them over to me and I will deposit them into my client trust account. If they have $50,000 worth of cashier's checks, they can bid up to $500,000. That would be 10% of the purchase price. Now there has to be, I'm qualifying them for how much is the maximum that they can bid for. And the bids have to be for all cash. There's no financing contingencies allowed in a probate matter. And the successful bid must be in writing, but I'll bring documents that can be filled out in handwriting to be able to put that bid in writing. But if no bid is made, the court should be confirming the sale to the original buyer and fix the broker's commissions. The first overbid amount has to be at least 105% of the purchase price plus $500. What I just said is the same as saying 10% of the first $10,000 plus 5% of the balance. Those two things mean the same thing. Here's an example. If we have a $400,000 purchase price, 10% of the first $10,000 is $1,000. 5% of the balance of $390,000 is $19,500. So the first overbid amount must be $20,500 more than our $400,000 purchase price. So the first overbidder must bid at least $420,500. Now, there has to be reasonable increments after that. The court is going to say $5,000 more or $10,000 more or $1,000 more. You just can't say, I bid $1 more and keep the bidding going. The court's going to want you to bid in certain increments. So that's how the auction works. There's a different process if the personal representative buys the house. There are two people in the world that if they buy the house, the court must have a court hearing, even if someone has full authority. It's the personal representative and the attorney for the personal representative. But believe me, I'm never going to buy one of the houses of an estate. I find that too much conflict of interest. So when the personal representative buys the estate's house, it is not an arm's length transaction because the personal representative is basically selling the house to themselves in one capacity as the personal representative of the estate and the other capacity as an individual. So this requires court approval. And there's two ways to get a court approval. Number one, everyone consents to the sale. We could file a petition with the court and show that everyone has consented to that sale and that purchase price. And the court hearing, there's no auction at that court hearing. Or if not every single person consents to the sale, then we have to go through that court confirmation of sale process, and there's an auction at the court hearing, which most personal representatives don't want to have because there's the possibility that they might get overbid and they'd have to pay more for the property. So the best way is to get everyone to consent to the sale, and the hearing goes a lot smoother. I just wanted to end up telling you guys about how to get leads if you want to know and work with more probate properties. It's great because we have motivated sellers. These sellers, if mom dies and has 4 children, no one wants 1/4 of a house if they don't live in. They want the money and they want to sell the house. And so looking back at all the cases I've ever had, about 2% of all cases have I ever kept the house. In all other situations, we're selling the house. So probate cases are a great way to get listings. And probatedata.com gives probate leads directly to your inbox. It's $147 a month, and you get 3 counties that you can get leads from. On the weekly basis, you're getting more and more leads. It's going to give you the contact details of the attorney and the personal representative of the estate. And it's also going to give you the house address. You could send us CMA. You can call the personal representative. You can send them mail. And if you just send them one piece of mail, you're not going to get any cases. You're going to have to consistently market to them and be of value, be of service, provide information, and be able to get those listings. So you're going to have to follow up, because one and done will not get you the listing. But being persistent will. I know I've had personal representatives where people show up on their doorstep or call them, and they get a lot of mail. So if you're going to be marketing to probate matters, you want to be persistent.
If I may add on that, we have a class on our YouTube channel that I did on how I started, cold calling personal representatives. And probably the best thing that happened was I met Sam and his staff through that process. So certainly one and done, like Sam says, is not going to happen, but you have to have a follow-up system and a consistent follow-up system. So thank you, Sam.
Right, correct. Yeah, absolutely. And when you're marketing, of course, You want to educate yourself and the personal representative, know where they are in that probate process. I kind of told you about that 6-stage probate process and what to do next. You can send them a CMA. You can offer comprehensive solutions, because sometimes people live out of state and they can't come to the house, but they need junk removal, or they need an estate sale. Sometimes the person's died in the house and they need biohazard cleanup, or they need an eviction or staging or fix up of the house. You might want to be able to offer a referral to a probate attorney or for self-represented parties. You can do direct mail campaigns, you can do cold calling, you can do follow-up, and always, because again, they're dealing with the death in the family, you want to approach them with empathy, compassion, and professionalism. And here's how to work with an attorney. I'm not looking to take food off of another attorney's plate. If they have a probate attorney, keep that probate attorney. I'm happy to be a resource to any of you. If you have some questions about a probate case, we could either set an appointment or give us a call, send us an email. If you want to send us a referral of a case that someone is self-represented, or if they have an attorney who doesn't practice in probate and it's kind of like, eek, I didn't realize this was so difficult. I think I should leave this to someone who does this all day long for a living. Get permission from the client for us to call them, and then just send a warm introduction email and include the client's phone number in that email.
If I may add a couple things here, Sam. Brandy is awesome. Like, you know, I ask her sometimes, are you really an attorney in hiding? Because she's not an attorney, but she is a wealth of knowledge. And she has Sam, right? So I reach out to Brandy quite often, and then Brandy will probably peek her head into Sam's office and give me an answer like that, right? And then I have some additional questions for you after you're done, Sam.
Yeah, for sure. No, it's the time for questions. What? Yeah, hit me.
Yeah. So one of the questions that I have, right, is what are your biggest frustrations as an attorney, as a probate attorney specifically, right, when you are dealing with real estate agents that don't understand probate?
So I'm very happy to explain the process. So I'll work with anyone. I mean, someone's got to get their first case, right? And if this is your first case, I'm probably a great attorney to come to, because I'm going to take the time to explain the process and what to do. And you and I have the same goal: close the escrow. And so I'm going to work with you any way I can to get that done. I would say the biggest frustration I've had is someone not being upfront and honest and be like, hey, Sam, this is my first one. Can we kind of go through what to do? I say, yeah, right on. Thanks for going over this with me. Let's talk it over, and I'll go through and explain to someone what to do and how to do it. And so I would just say kind of being upfront about your experience level. And if something gets weird and hairy, let's talk it out and come up with some solutions. You know, there's sometimes solutions that I don't have, and maybe you don't have either. None of us have. When you have the personal representative of the estate, they live in the house, they're the son or daughter of their parent that passed away, and they don't have the money to move. I don't know how to solve that for somebody, because if they sell the house, they won't get their inheritance for months later. And where are they going to live in the meantime? That I've never been able to quite solve. There is possibilities for someone to take a little advance on their inheritance, but it's expensive money. You take a $10,000 advance, you have to pay back 20. And so it's expensive money, but that's one way we could do it. But sometimes there's not an easy answer to the solutions for folks. So sometimes we need to collaborate and work on something together. So I would just say communication about the issues in a case or experience level of doing probate matters would probably sometimes have been my biggest frustrations of working with other professionals.
Sam and I had a case, the Bank of America lady out of Florida.
Yes.
And
yes.
I was quite frustrated with the squatter that was in there, and I called Sam. We were supposed to close. I called Sam, and Sam gave me some really good ideas to speak to the administrator and get an extension, right? So Sam is right about working together to make the deal happen, because if the property doesn't sell, then Sam doesn't get his fee that he has to wait for, that the state of California has set for him. The other thing is Sam will actually call you back. it's amazing, right? Most attorneys that I've dealt with, I email them, and then I get frustrated, and then I have to go to the administrator to let them know, like this is the realtor that I've chosen. Can you please return his calls, or the emails, right? And it's like, I already have the listing, I already have an offer accepted, and I'm asking the attorney to please, get started with the NOPA. Silence, right? So Sam is really good about that. If you have a case, because typically, right, the real estate agent is going to be the gatekeeper. You
Yes.
sold the home. You sold the home to mom and dad. Mom and dad passed away. Now the kids have heard of you. They're going to call Brandon. Hey, Brandon, I need to sell the house. Then you go pull title, and it's, husband and wife that joint tenants, but they don't exist, right? It is not in a trust. Then that would be a case that certainly Brandy and Sam can work on, and they can do the probate. Now, if we refer a deal to you, Sam, do you endorse, or do you tell your administrator, hey, this is the, like, give it back to us, basically?
Yeah. So if I am getting referred a case from a broker or agent, that is the broker or agent for the sale of the house. I would never refer that client out to someone else. And so I would talk with them about, once we get appointed, you can sign a listing agreement with that person that referred the case to us. So yeah, absolutely, that case is yours. Now, there are times when a client comes to me and either they're out of state, or they don't know an agent or broker, and I have the opportunity to refer that person to someone, and I do. And I might be a lot like you. I refer cases to people that refer me cases, and so I don't ask for any piece of the commission. I don't give you any piece of my legal fees. But there's a way that we can work together to be able to send work to each other.
Now, understand, and I want you to hear what Sam said. He doesn't ask for a piece of the commission. What did you do prior to being an attorney, Sam?
So I was, my mom has flipped houses before there was even a TV show about it. She's been flipping houses for 50 years, and she's still doing that. She just bought a vacant lot in Highland, and she's trying to figure out how many properties she could put on this lot. She thinks 4 to 7. And so I have been a real estate broker. I've been a licensed contractor. I've flipped houses. But we did it before today's market, where you've got, oh my goodness, people doing 30, 40, 50 deals a month or more. We did like 3 or 4 a year. And so it was a very different time. So I'm very familiar with closings, transactions, real estate. I speak of the language of a broker or an agent. But I can bridge the gap between the law and real estate. So at least we could at least speak the same language and know what each of us are talking about.
One more, Sam, and then we can open it up. We have about 4 minutes, but I wanted to talk about pro per, self-representation, right? And why do they need to? Why do they usually come to you at the 90th yard line?
So even attorneys that practice in other practice areas get caught up in probate. Probate is really a specialty area, and it goes back to the times in England when the probate court came through the chancery courts. These were courts of equity, not courts at law, and you didn't have a right to a jury. It was all judge law, and the courts operate differently in probate. And you might be able to get a paralegal to help you to get appointed in a case, but that's where the complexity really begins. The easiest part is getting appointed with letters. The hardest part is administering the estate properly. The hardest part is doing an accounting when you have to close out the estate. And that's where people get stuck, and they can't get their inheritance. They can't close their case. The judge is on them. The other heirs of the estate are on them, and they don't know how to finish it up. And my fees are set by California law, whether I start in the beginning of a case or at the end of a case. And so I tell people, like, look, you're going to have a hard time closing this out. Just hire an attorney as soon as possible. That way, it is the easiest transition for you to get this case done, because the easy part is getting appointed. Everything else is hard, and most people can't handle it. So self-represented folks need an attorney to finish out their probate matter. It's not as easy as they think. So a lot of times people are hiring us much later when they realize, uh-oh, I'm stuck. I don't know what I'm doing. I need an attorney to finish it up. But by then they could have gotten a lot more value had they hired me earlier.
And they could be 90% done and you still get your complete fee, correct?
True. 100% correct. Yes.
Yeah. Do we have any questions? Just unmute yourself. Go ahead, Christian.
Sure. I have actually a few questions.
Yeah, buddy.
Now that you're talking about the attorney fees, I'll bring up that one. Sam, so how much do you typically see for extraordinary fees that either from the realtors, from the attorney, or from the, let's say, the administrator that needed to collect or pay some fees out?
Great question. So there are two parts to attorney's fees. One is called ordinary services, and those are those percentages I mentioned, and those are set by California law. In addition to ordinary services are extraordinary services, and extraordinary services go hourly. And sometimes extraordinary services are something like there's some litigation in a case. Maybe there's a will contest. Maybe there's a petition to determine who the heirs are of an estate. So there can be situations in which there's some type of litigation that goes hourly in addition to the ordinary services. So one of the extraordinary services that are allowed are when there is real estate that has to be sold. For me to do a NOPA or for me to do a court confirmation of sale, that allows for additional extraordinary services at an hourly rate. For a NOPA, I'm typically looking at about $1,500 of attorney's fees. For a court confirmation of sale, that's probably a few thousand.
Very well.
Okay.
That's typical fees involved with selling a house.
Perfect. Thank you. I also have a few more questions. That's okay.
Yeah, buddy, go ahead.
All right. So as far as the administrator, I understand that they get the same pay as what you're allocated to.
Yep.
But do they also, if they're an heir to the estate, do they get a portion of whatever that shares as well?
Yes. So they will get both. And from a tax standpoint, receiving an inheritance is not taxable to the person that receives it. But if you take a fee, that fee is taxable. It's income. So if you're the only heir to an estate, don't take the fee, because you're turning what's not taxable into something that's taxable. Now, even if there's only two heirs to an estate, sometimes they're telling people, do you really want to take your fee? Because look, you're paying half of it and you're taxed on it. So how much really are you netting out of this? Why don't you just make a deal with your brother, your sister afterwards and just like split some money, right? The other thing that happens is if you are there are a lot of heirs to the estate. If there's 4, 10, 20 heirs and your share is small, take your fee, because the portion that you're cutting out of your inheritance is small, but you'll receive a lot more than had you not received the fee. So yes, they will get both their fee and their inheritance, but sometimes you don't want the fee.
So we are at 11:01, maybe another 1 or 2 minutes, and then we got to let Sam go back to his conference.
Hey guys, look, if you're finding value in what we're saying, I'll stay on. I'm good. I'm good to stay on for as long as you guys need me.
Thank you, Sam. Any other questions?
You got some more, Christian? I know you do. I can see it.
I do.
I see in your face, man. Go ahead.
Okay, so let's say the mother dies, and then the daughter takes over the property, and then she has to start paying the mortgage because that's what she assumes she has to do. Is she gonna have to continue paying it throughout the entire year and a half, or how long the probate process goes, or is there a way that she could pause it, or what's typically the process?
Yeah, the mortgage company wants their money. She's gonna have to keep those payments up. So someone's got to pay the mortgage. They can foreclose. There's no exception for a probate matter. The only difference is if there's a reverse mortgage. So if there's a reverse mortgage, there's no payments typically. And once the owner of the property dies, that reverse mortgage is supposed to be paid back within 6 months of death. They regularly give extensions of time, especially if they know you're going through a probate matter. So communicating with them is really important. But so there's no cure for a reverse mortgage. But if you have monthly payments, those got to be kept up.
Okay.
Now, whoever pays that mortgage, if they're not living at the property, they're entitled to be paid back if the house is vacant. But if they live at the property, the court's going to be like, hey, man, did you live there? Should you really be paid back? Because you had to live somewhere, but you're living at the property, you're paying the mortgage payment. Maybe we don't charge you rent and we use your payments you paid in lieu of rent. So
Yeah,
this is going to happen.
Okay.
one of my cases in LA, he's been the gentleman, the stepson has been there for 2 years, never made a mortgage payment, but the administrator is making the mortgage payment. And I told the administrator, keep track of everything, because what people don't understand, right, especially if you are like, he's made it difficult. This is I've been with this case for 2 years. The person that's occupying the property is making it difficult. He doesn't understand that will probably, will be accounted for. And he's essentially not getting more money than he should have if he would have just made it easy and moved out 2 years ago.
A question based on
Yeah,
that.
Emily.
So if you so if the heir doesn't have the money to pay the mortgage, then essentially the bank's in first position regardless, right? So wouldn't then the bank just take over the probate process and distribute at the end of the process to the heir, so that the heir didn't have to come up with them, like the heir didn't have to handle the process? Wouldn't the bank just take over and foreclose?
Typically what the bank does is they foreclose, and when they foreclose, there may be excess proceeds that are going back to the estate after they foreclose, but they don't take over as administrator of the estate. Usually it's going to be a family member. Sometimes that can be the what's called the public administrator. Each county has a department of the government that is the personal representative of last resort when no one else is there. Or it could be a professional fiduciary that takes that over, but the bank just forecloses. And then so someone has to keep up those payments, and if they don't, then they could foreclose.
Got it.
Yeah.
Then that complicates the process even more and drags it out another extra however long, right?
It can. And so I have a case now where there's excess proceeds, and we're in the process of asking for the funds. And we put that money in the bank account for the estate, and those excess proceeds get first we have to pay the bills of the probate or any bills that the decedent had, and then the money, the remainder goes to all the heirs of the estate.
Got it.
Yeah, if you have the listing and they are in the process of foreclosure, it's crucial that you communicate with the bank to let them know, look, I have a listing agreement. It's on the MLS. Give us some time, please. I've been in that situation where they will give us an extension. Any other questions?
Can I just comment on that, on the foreclosure issue? So January 1st of 2025, brand new legislation came out that if you give a listing agreement and there is a foreclosure sale date, they must give you a 45-day extension.
Oh.
Then if you give them a purchase agreement, they have to give you another 45 days. In a probate matter, I can always file a temporary restraining order in the case, but that takes time and money, and I've got to convince a judge to issue the TRO. So what I'm going to do, Roger, I'm going to email you information about the ability to get an extension of 45 days for a listing agreement and for a purchase agreement, so that and I have a sample letter that I've written, so I want your office to be aware of that, and that's a great tool. I've already used it, it already works, and so this law just came out effective January 1st of this year.
Awesome. Thank you very much, Sam.
Yeah, buddy.
Any other questions?
What you got, Christian? What you got, Christian? Come on,
I
man.
got one more.
I know you do.
All right, let's go on to wills. So let's say if there is one will that was written 20 years ago by a mother that passed away, and the daughter finds it going through the mom's stuff, and that's the only will there is. Is that typically like something that's pretty simple to move forward in the courts, or is it something that usually gets contested?
So most people die without a will if they're going through probate. The cases that do have a will, it depends on the validity of the will. So you could take a cocktail napkin with a crayon and write out what you want to give and sign it. That is a will. So I've literally had something on one of those little steno pads with all the little curlicue things. I've literally had that said, I give everything to my daughter Cindy. Love you, Cindy, mom. And she signed it. That was a will, was admitted to probate. Literally, I just read what the will said. She was an only child, so she got everything anyway. So it didn't matter. So if the will is giving out what you would, if you have 3 kids and you give everything equally to 3 kids, there's no fight for that. Who's going to fight? The fight comes when there's 3 kids and one of them gets disinherited. That's when there's a fight. So, but not always. They don't always fight. Some people say, you know what, I wasn't in mom's life. Maybe I won't get anything this time.
What about an email? Like if you send an email saying, I'm going to give you my house.
Yeah.
Does the email hold up in court?
Unfortunately, no. A will is required to be in writing and it is required to be signed. And so if it's not signed, an email isn't signed, and you can't, there's no electronic signatures allowed for wills. The Uniform Electronic Signature Act excludes wills from electronic signatures. It must be wet signed. So there's no texting, no email.
What about notarized? Does it have to be notarized?
A will is not required to be notarized. If it's not in the decedent's handwriting, then there must be 2 witnesses. A notarization is not required in California, but a notary can be treated as one of the witnesses to the will.
Which, by the way, guys, I had a case again with Sam that the squatter produced a will with 2 witnesses.
Yeah,
and that was no good. It's a fake.
That's what I was going to say. There has to be so much fraud around this story. Oh yeah, I found this. It's got the
Yep.
Isn't there fraud related to that?
That particular case that I had with Sam, the decedent, the deceased signed a grant deed, but it was recorded after his death. It was crazy. So yes, you will. It's crazy stuff, and I was like ready to get that listing, and then Sam had to go back to court.
Yeah, we got the house back in the estate, but that happens. Yeah, is there fraud? Yes, absolutely. In general, the court's kind of against fraud. I don't know. They're usually not cool with that. So yeah, but the fraud does happen, of course. Fraud is legal lying, right? Fraud is the lawsuit when someone lies, whether that's in writing or verbally. Yeah.
All right. Well, thank you very much. I think we're gonna shut it down. Sam, thank you so much for being here and being a resource. And I will wait for that letter, and then I'll send the recording to everybody that registered and everybody that is attending. And if you guys have any questions, Sam's information will be on there. He's awesome. So thank you very much, Sam.
Appreciate you, Roger. And thank you all for being here today. Appreciate you. Have a great day.
Take care.
Thanks, guys.
Bye now.
Bye-bye.